7 key points that you need to know about the examination for discovery stage of a lawsuit. I'm Natalie Gerry, the principal lawyer with Gerry Law. I help injured people get the compensation they deserve for their injury. Today, we're talking about what you need to know before you go into your examination for discovery. If you're involved in a lawsuit, you'll go through a stage called the examination for discovery, and this is one of the most important steps. It's where both sides get to ask each other questions to better understand the case and to prepare for trial. So here's what you need to know in 7 steps, explained in pretty simple terms with some examples. First of all, what is an examination for discovery? So the examination is an oral examination where you'll answer questions under oath about the issues in your case. Think of it like an interview with the other side's lawyer, but instead of being casual, it is a more formal meeting, not court formal, but a little bit more formal, and it is part of your lawsuit. So a court reporter will be present to record everything that you say. There is no judge there, but the evidence can be used later in court if needed. So for example, if you're injured in a slip and fall accident at a store, then the other lawyer might ask, can you describe what you were doing before the fall? What injuries have you had since the accident? Have you missed any time from work because of your injury? The goal of this is to gather facts and to avoid surprises at trial. The second thing to know is about where the discovery happens. So it's not held in a courtroom. Instead, it usually takes place in a boardroom or an office. This setting makes it less intimidating than being in court, but it's still formal because you are under oath. The third thing to know is the purpose of the discovery. The examination for discovery has several important goals that you should be aware of. The first is to learn about the other side's case, so both sides get to understand each other's evidence and arguments. The second goal is to avoid surprises, so by sharing information, there's less chance of being blindsided at trial. The third goal is to gather admissions, so if the other party admits to something important, then it could strengthen your case. The fourth goal of discovery is to encourage settlements. So once both of the sides see the strengths and weaknesses of their cases, they're often more willing to negotiate a settlement instead of going through the full trial process. The fourth point to know about discovery is what happens before discovery. So before the examination, each side must exchange what's called an affidavit of documents. This is a list of all of the evidence they have that's relevant to the lawsuit, and I do have another video about affidavits of documents going into more detail about what the format is and what your role is as the client and what is contained in there. So that video will be linked below. But some of the important notes about documents. So documents includes more than just paper. It can be emails, text messages, photos, videos, or even voicemails. It's also important to know that you have to preserve all relevant documents, even if they're on your phone, your computer, or in storage. If you lose or destroy documents, that can hurt your case. So for example, the judge might prevent you from using certain evidence, or in extreme cases, the judge might dismiss part of your claim. By way of an example, in a car accident case, you might need to provide photos of the damaged car, medical reports about your injuries, or emails or texts about how the accident has affected your ability to work. The fifth thing to know about the examination for discovery is about what they can ask you. So the other lawyer will be asking questions about the incident, about your injuries, and your losses. The questions must be relevant to the case, but they can cover a wide range of topics. So the lawyer can ask you on a variety of topics. They have a pretty wide discretion to ask. Some examples of questions in a personal injury case are things like, what injuries did you suffer because of the accident? Have you been in any similar accidents in the past where you've had injuries to the same areas? What medical treatments have you received since the incident? And how has the injury affected your daily life? Your lawyer will give you a more concrete list list of questions that you could be asked so that you're able to prepare in advance. The other thing to know is that your lawyer will be there the entire time that you are being asked questions. So if the questions are inappropriate, then I would always jump in and say to not answer. Most of the time, the defendant's lawyer is doing their job and asking questions, so there is no need to jump in. But if there is an inappropriate question, then I would be objecting to that. The sixth thing to know is about how to prepare. So here, your lawyer, I would definitely help you to get ready for the discovery. We will go through the important documents in your case and make sure that you are certain of what was in your statement of claim. We can also go through practicing answering questions so your lawyer can practice with you so you feel more comfortable answering questions. You also need to make sure that you're being honest, so always tell the truth. And if you don't know the answer to a question, of course, fine to say, I don't know. In fact, it's preferable if you don't know the answer, just to make sure that you would say, I don't know the answer. The seventh point to know is what happens after a discovery. So after the examination, the lawyers will review the evidence that came out and decide how to move forward. Sometimes the discovery stage can lead to a settlement because both sides better understand the case and see each other's side. And if the case doesn't settle, then the next step is preparing for the pre-trial and the trial. So the examination for discovery is a very important step in your case. And if you have any other questions, do not hesitate to reach out to me. I would be happy to speak with you about this.